And then I brought you, there was a heated moment between Tsatsu Tsikata and the Godfred Dame court. Efa Gyachi Kwesen case no eso. Na ohwe nsɛm a na eba utumi hu ne sɛ Godfred Dame nsɛm a na wo ka tre Tsatsu Tsikata no I don't know. I say Godfred Dame nsɛm a na wo ka no I say na no ohio I say no hu Tsatsu Tsikata so ya kola bi o sɛ de nsɛm bia na wo ka na Tsatsu Tsikata tre ne sɛm asa me nya kola sa low level na nya dia meba me feel. And it was serious. Okay, that heated moment I yet is serious. Now, I have an article on that, and we are going to read what went on in Parliament. In court between Tsatsu Tsikata and Godfred Dame. Into her title now, Ghana Web Ediabana will say, your application is unmeritorious and incompetent. Dame tells Tsatsu Tsikata. Into no, just say Godfred Dame katre Tsatsu Tsikata say, ne application bi obefile wo court no wo hwe na Tsatsu Tsikata o sa akola mamu mo lawyer Tsatsu Tsikata no anyway it was Tsatsu Tsikata ne application bi a wo de eba be pim another bar court no unmeritorious. Now you can say bibi unmeritorious atre say something without merit bibi a any merit bi an na atre say aba enim ati ase just aden aba enim sebe nyansa bia enim na tese Godfred Dame nsem a no wo ka se Tsatsu Tsikata ensem bia wo de aba begina court no sa nete aba bia enim nyansa bia enim. Okay, that's what Godfred Dame was saying. Now what the Attorney General Godfred Dame has described as incompetent, unmeritorious and unknown to the law on criminal procedure, a motion filed by veteran lawyer Tsatsu Tsikata in the James Gyachi Kwesen Pedri case. Okay, Yankongo he a motion bay. Also, the Attorney General was opposing a motion filed by Tsatsu Tsikata seeking to set aside an order of the court to conduct a day-to-day trial of the case of Pedri against Gyachi Kwesen, the deposed member of parliament for Asin North. Also, Tsikata sought the authority of the court to suspend its day-to-day trial in order for Gyachi Kwesen to pursue his desire to campaign and contest the by-election in his constituency occasioned by his sacking from parliament on grounds of ineligibility. However, the Attorney General, founding himself on several legal authorities, argued that the application before the court was alien to the law. Also, every step that ought to be taken in criminal procedure is clearly regulated by the Constitution and the Statutes of Ghana. The laws on criminal procedure, from the Constitution to Act 30 and the practice directions on the conduct of criminal cases, do not permit his application. In the assembly, Ninane say, Yama ruling said Gyachi Kwesen umbra every single day. And Tsatsu Tsikata said that court entry ruling no ebium. Na Gyachi Kwesen no, our campaign was so kokoye. Oka umbra every single day ya. O sabotage no. It is Tsatsu Tsikata beka tre court say, wo mo hwemu no, enu mu ne say Godfred Dame sorry ya wo kasa asem na Tsatsu Tsikata e kan sebe aba enim. Nyansa bi enim. Eni Ghana mremu. Eye alien to the law, na tre say ensi wo Ghana da. Inti minim, I don't know whether he was referring to the details of what Tsatsu Tsikata said or what he was saying alien to the. Is it that reviewing a decision from the court, filing for a review of the decision from a judge, and then a alien to the law and I said yen. Because we change someone working or say criminal cases biano, there are laws on criminal procedure, Ghana, Constitution, Act 30 emu, and in sensem, and person say criminal cases do not permit this application. In them said you know person can say criminal case biano. To me for application, but say judge am ruling or case this way we was won't review. That is what Godfred Dame was trying to say. And me, I'm not a lawyer. I don't know whether what he's saying is true or not. But at the end of the day, Tsatsu Tsikata won against Godfred Dame. Assembly. Tsatsu Tsikata won the review. I think so. Because at the end of the day, Gyachi Kwesen say onko ye the campaign. if the thing was alien, and at the end of the day, judge and cast okay, Tsatsu Tsikata asem yede. But Godfred Dame someone no canono, asem na baby enim, incompetent. A baby enim, yansa be enim, na Tsatsu Tsikata na ade we are wo ye. What's that? As a Tsatsu Tsikata yakola. Also, he described the approach by Tsatsu Tsikata as a grand attempt to waste the court's time, which militates against a speedy trial. Also, Godfred Dame stated that, first, the Constitution enjoins a speedy trial of criminal cases. The Constitution is clear in Article 19(1) that a person charged with a criminal offense shall be given a fair hearing within a reasonable time by a court. This provision in the Constitution is to ensure that criminal cases are disposed of in a speedy manner. Also, further, the practice directions for trial cases issued by the Supreme Court in 2017 require criminal cases to be heard from day to day. Also, the Attorney General also argued that, per the provision of Article 17 of the 1992 Constitution, all persons are equal before the law. Also, if a teacher or farmer cannot refuse to attend or resist a daily hearing of his criminal case because has to go to work, why should a politician be able to avoid trial because he wants to go and campaign? Also, the Attorney General argued that a grant of the application would result in discrimination contrary to the Constitution. Attorney General Zemo kan wako no. Say yema jaji kwesi nkoko ye campaign na tre say tiaga na mra. So the Attorney General pointed out that he cannot understand the claim of lawyer for the accused person that if his client appears before the court on 22nd and 23rd of June, the right to vote of the people of Asin North, who are not parties to any case before the court, will be affected when none of the constitutional rights of the Asin North constituents have in any way been tampered with. Tsatsu Tsikata will file review na nsem be reasons be our kind and they say was say jachi kwesi nkoko campaign any nsem otherwise be affect Asin North for any all that. It's no na say Godfred Dame kan wo court say masa enya Asin North for na di omo aba court jachi kwesi Asin North for nkan nsem ne ho. It say unim na be kan nsem we ya den na person patre Asin North for no omo asem we for omo ho. So what are he saying? Also, the Attorney General supported his argument by citing sections 168 and 169 of the Criminal Procedure Act 1960 Act 30. He signaled the importance of section 168, which is titled Appearance of Both Act Parties. Also, the provision states, where at the time appointed for the hearing of the case, both the prosecutor and the accused are present before the court, or if the prosecutor appears personally or by counsel and the personal attendance of the accused person has been dispensed with under section 70, the court shall proceed to hear the case. Also, section 169, which is on adjournment, states that before or during the hearing of a case, the court A may adjourn the hearing to a certain time and place to be then appointed and stated in the presence and hearing of the parties or their respective counsel then present, and B, in the meantime, may suffer the accused to go at large, or may commit the accused to prison, or may release the accused on the entry into a bond with or without sureties, conditions for the accused person's appearance at the time and place to which the hearing or further hearing is adjourned. Ntinafe wo koti Ghana mra on judges no say no be to me agenda case and no be to me ama yachi obi any sense nsem ni nyina no. In terms of person try say judge ni decision I will take here against a year judge question say one bra every single day no ma judge no match Tsatsu Tsikata nkan nsem for front no so decision no a right a ade a na a pa montie chachu kekan nsem also on the basis of these provisions, the Attorney General urged the Criminal Procedure Act gives the court the power to decide the venue, time and date for court sittings, and no other person or authority has the power to determine same or to change it. Just like I'm saying. Say judge ruling awama no, emrama ne kwanso onye sa ruling no. So waka se chachi kwesi nembra every single day no embrama judge ne kwan montie asemo NDC for ne Tsatsu Tsikata eka. Say according to the Attorney General, the case of Republic versus Eugene Bafo Boni established that criminal trials must be prosecuted within a reasonable period of time and that the courts of first instance must do everything possible to sit as regularly as possible to ensure that this is achieved. Tsatsu Tsikata, in opposition to Attorney General's arguments, averred that a speedy trial did not necessarily mean a day-to-day trial, despite it being stated black and white in the practice directions of the court. Inti utie Godfred Dame argumenta, or say criminal cases there. I was say ye no intentem eno kotim ra etre say criminal case bi and was say yetumi di nentem. Asema na Godfred Dame kan no. Ya na ye refi. Ya no bi say inti ameswal in a criminal case ndi nja na yetumi di nentem. Anyway, that's just by the way. So say criminal case bi ana JB dan kwa say achi nipa kro kokokun JB dan kwa na sa case ni ndi nentem. But say criminal case there Ghana mrajo say say di nentem. Inti ye ka chachi question embra every single day because ye person ye di criminal case ni ntem inti judge no mo mfi chachu e na chachu so no ka se masa say ya ka se ye di criminal case ntem a ene nche say every day ye man nipa kron mbra court si ye ka se ye di court asem ntem a ene nche say every day wo mbra court dabi inti ene de yi free. Also he further argued that his client had a constitutional mandate to participate in politics and that the right to vote of the people of Asin North will be adversely affected if the case proceeds from day to day. The trial judge, Mary Yanzu, adjourned the case to Friday, June 23rd, to rule on the day-to-day trial. Her ladyship, however, excused the Achikwesin from coming to court on Friday for the ruling. Oh, okay. Naturally, say, Afiansa ruling, day-to-day ruling, no eba. Naturally, so China, hey, inti betu me aka say, okay, yen fee. Hey, yeah, semo. But you see, Jachi question on there for the meantime, no more back courts. Hey, don't tell me what your comment was in why, me that's it.